Here's the situation. You're holding on to a property in East Tennessee, and maybe you inherited, or maybe you relocated and held on to your Knoxville home while the market figured itself out. Maybe you couldn't sell, or just renting it out made more sense. Either way, you've got a tenant or you're about to get one. And right now, without realizing it, you may already be exposed. My name is Darius. I run RPM Marble City, a real property management franchise here in Knoxville. I've helped over 50 property owners navigate this market, and today we're going through the specific legal and financial threats that hit accidental landlords in Knox, Blount, and Sevier counties before they even see it coming. Let's get into it. Tennessee operates under a law called the Uniform Residential Landlord and Tenant Act. It applies to counties with a population of over 75,000. Knox, Blount, and Sevier counties all operate under it. Loudoun County runs on a different set of rules. Here's what that means for your lease. That document that you downloaded off the internet has a real chance to be illegal with late fee clauses. Most generic templates still charge from day one or use a rate of 15 to 20%. Under that URLTA, you can't charge a late fee until after a 5-day grace period from the date the rent is due. And the maximum you can charge is actually 10% of what's actually owed, not 10% of the monthly rent. In Knox, Blount, and Sevier counties, those clauses don't hold up. They're void, and the tenant knows it. A professional tenant absolutely knows the Tennessee law and can pay base rent only, dispute every fee you've charged, and walk into court using your own lease against you. That's not a worst case scenario, that's a pattern. So let's say the tenancy goes sideways. Here's your timeline. You issue a written 14-day vacate notice. That notice has to name the specific breach, and it has to state the exact amount owed. It has to be delivered correctly. One defect anywhere in that document, the wrong language, the wrong timeline, and delivered the wrong way, and the case gets dismissed. You have to start over. Once everything is filed clean, the process runs. You're looking at 4 to 8 weeks from filing through the hearing and appeal period and an order to vacate, assuming nothing gets contested and assuming there are no continuances. The average rent in Knoxville runs $1,400 to $1,500. And within a 2 to 3 month period of that sitting unpaid, the clock runs. That's $3,000 to $4,000 gone before you even pay a single legal fee. Add $500 to $1,500 in court costs and another $1,500 to $4,000 for turnovers when they leave, for cleaning, painting, repairs, and vacancy expenses. That's $7,000 on a low end. In contested cases in Knox County or Blount County, they go even higher. One defective lease, one wrong clause, and that's the cost. Security deposits are our own minefield. Under the URLTA, deposits have to sit in a dedicated account, one used specifically for security deposits only. And you have to tell the tenant where that's located at signing. Skip that step and you lose the right to keep any portion of your deposit, even when the tenant caused real documented damage. I've watched landlords stand in front of a judge with photos of a destroyed unit and walk out with nothing, all because that deposit was sitting in their own personal checking account. That's not a legal technicality, it's just the rule, and it's one most commonly made in litigated situations in Knox and Blount County. So here's what's running the right way actually looks like. First, the lease. Tennessee compliant, built for your county, late fee language, deposit terms, entry rights, default provisions, all of it aligned to the law before anyone signs. Second, screening. We run a full check on every applicant. That's credit, debt to income ratio, eviction background, criminal background, income verification, landlord references, and we apply that same standard to every single person who applies. Why? Because the federal fair housing law requires consistency. Running checks on some applicants and not others is just simply careless, and it creates a liability. Third, deposit handling, separate accounts, written disclosure at signing, tenant present at move out with an itemized list delivered that required window, every step documented. Because the deposit you handle right is the only deposit you actually get to keep. I spent 20 years in the Air Force running operations where the margin for error was zero. You don't build those systems after the situation arises. You build them before. That's what I brought to this business. And that's the difference between an investor who gets to sleep at night and one who has to go to General Sessions Court explaining their lease to a judge. If you've been managing your property yourself or you're stepping into this for the first time, The most valuable thing you could do right now is understand your exposure before something forces you to. I offer a free consultation. That's no pitch, no pressure. We go through your property, your lease, and your numbers together. If there's a problem in your setup, I'll tell you where it is. If there isn't, I'll tell you that too. There's more than 50 property owners and investors in East Tennessee that I've already had that conversation with. The link to schedule that is right below this video. You went from being a homeowner to an investor, and that's something you should be proud of. Let's make sure you're running it like one.